Honorable, the Supreme Court of Texas. All persons having business before the Honorable, the Supreme Court of Texas, are admonished to draw near and give their attention, for the court is now sitting. God save the state of Texas, this honorable court.
Please be seated. We'll hear arguments in three cases this morning. First is 23-317, Leibman versus Waldroup from Harris County and the First Court of Appeals District. Then 23-644, Kensington Title, Nevada versus Texas Department of State Health Services from Travis County and the Third Court of Appeals District. And finally, 23-704, Seward versus Santander from Dallas County and the Fifth Court of Appeals District. The court has allotted 20 minutes for each side in each case, and we'll take a brief recess between the cases, completing them before lunch. The arguments are being webcast live this morning and will be available in the court's archives later today. We're ready for argument in 23-317.
May it please the court, Ms. Chang will present argument for the petitioner. Petitioner has reserved 5 minutes for rebuttal.
May it please the court. The issue presented is whether the Waldroup's claims based on Dr. Leibman's provision of a letter for his patient stating her dog performed a task which treated her general anxiety, medical disorder, or healthcare liability claims. An examination of the Waldroup's claims as pled and the evidence in the record establishes that the claims are healthcare liability claims arising from the patient-physician relationship and concerning the patient's medical care. Moreover, the necessity of expert testimony to prove or disprove their claims is dispositive of the claims as healthcare liability claims under Texas West Oaks and more recently under Coming Attractions Bridal. Whether Dr. Leibman was reasonable in his use of his professional judgment to determine Kingston was trained to perform a task which controlled her diagnosed general anxiety and allowed Romano to perform daily duties. Therefore, treating her medical disorder requires specialized knowledge.
Is that in dispute? Do you dispute that that it would have been helpful for her to have a service dog to treat her disorder?
I don't believe that has been disputed, that it would be helpful.
So what is it that a medical doctor needs to provide an expert report about? What is the alleged negligence that relates to treatment or lack of treatment or departure from an accepted standard of medical care that's causally linked to the incident here?
The issue is whether the representation of the service dog, Kingston, provided a benefit to the patient and the context of whether that service dog, Kingston, was within his scope.
So you don't dispute that a service dog would have provided a benefit to the patient, but you dispute that this service dog would have provided a benefit to the patient?
We don't dispute that.
So
there is a dispute as to the dispute before this court is whether Kingston provided a service with regards to her medical condition.
But you just said you don't dispute that.
No, whether he was qualified to provide that information with regards to this dog providing that task. Not the necessity of it, but whether this dog was qualified to provide that task and whether it was in his scope of practice. So his scope of practice is the question that's at issue. And as
is it your position that the doctor made a determination about Kingston's qualifications or temperament?
The doctor has to make a determination not on the temperament, but whether under the ADA this dog would lessen or alleviate or prevent a medical condition or disability.
Did this doctor ever have any contact with this dog?
No, he did not. And that is a question within the scope of practice as to whether a physician, what does a physician need to do? That's why expert testimony would be necessary to determine exactly what the Waldroups are claiming, which is what steps are required with regards to determining the task that this dog is trained to provide? What information does a physician rely on in making this determination? That's the scope, Justice Busby, of the medical care that we're looking at.
But aren't we talking about the provision of medical care being a determination, two things. Number one, whether or not that type of treatment is necessary for this patient. But then another issue is whether or not this particular animal is an animal that could fulfill what is needed for that treatment, right?
Right, so we're looking at whether a service dog, this service dog, provides a trained task that is connected under the ADA.gov, which is in the record, as referenced on 212 by the Waldroups, whether the service animal provides a task that is connected and either prevents or lessens a patient's condition or disability.
But none of that, I mean, the claim here is not that the doctor, determined that the animal would lessen the disability and it didn't, and so she had some sort of medical complication as a result of that. You could see that being a healthcare liability claim, perhaps. The complaint here is that the dog was improperly trained for other reasons and was dangerous, in fact, and bit somebody. And so I guess what I'm trying to understand is how what you say, you've said what we need to know is whether it's within the scope of the doctor's practice to say that this particular dog, or maybe dogs in general, would lessen or her condition or help treat her condition or disability. But the negligence doesn't have anything to do with whether this dog would lessen her disability, because the problem wasn't with her disability. The problem was with the dog's other behavior.
But if we look at what the pleadings, and that's what all of our cases for the past 20 years have said, is we look at the pleadings. The pleadings in this case in the record on 5 say that Dr. Leibman was the provider of a letter to Romano asserting Romano needed her service animals to help with her anxiety. Those are the set of facts. The background then is that Dr. Leibman, Romano's gynecologist, prepared multiple letters regarding the patient's general anxiety disorder, and that having her animals helped her with the disorder. Their argument, their pleading, is the representation that this animal helped with her disorder and therefore was a service animal. That's what they're arguing is the crux of their case, that Dr. Leibman provided the patient with a letter regarding her condition that was treated by the use of this animal to provide certain tasks, which he then stated in the record.
Whenever you look at the little SIGA factors that we're supposed to look at in determining whether something is a healthcare liability claim, and certainly one factor is whether the claimant is a patient. Another factor is where does this occur? Is it in a doctor's office? Is it in a hospital? It seems that all of those factors, or most of those factors, are certainly going against the idea that this is a healthcare liability claim, correct?
Well, first of all, when we look at the basic elements, the 3 basic elements that the court has talked about with regards to whether there's a patient, physician, the defendant is a physician, we've got no dispute there. We then look at to whether it is a departure from an accepted standard of medical care. That's the crux of this argument, the core argument there. Then there's no dispute with respect to whether or not the alleged defendant's conduct proximately caused the injury in this case.
Well, but we have to be clear about what the conduct is.
Right.
And so that's why I'm asking. If the conduct is that the doctor approved a dog that for other reasons was going to harm other people, maybe we need a veterinarian and not a medical doctor to provide an expert report.
Right, which is why we look at the context, and all our cases tell us the totality of the circumstances in which this letter was provided. And so the actual letter states, and is in the record, due to the patient's anxiety disorder, she needs all of her service animals. And then Kingston walks into every entrance before her and where she goes. Those are the facts. And the conclusion in the petition is that it appears she needs these service animals to control her anxiety and perform her daily duties. So the complaint is that Dr. Leibman, outside the scope of his practice, represented the service animal benefited this patient. That is the claim.
But it's undisputed that it did.
It is undisputed that it did, and so they're arguing that he should not have represented that this service animal benefited her with respect to her generalized anxiety disorder, this particular animal.
What if instead of recommending a service animal, the doctor's letter had said, this patient has some back problems and needs a standing desk. This patient can't sit all day. Is that the same situation? Is that analogous? Because that seems to be a far more common scenario. And what if the doctor's letter goes on to say, and I recommend this brand?
I think that that's similar, and it is a healthcare liability claim, but I think that also analogous would be going to a physician with regards to playing sports, an orthopedist, and whether the ankle injury then would be something that would permit the patient to play sports. What's the relationship between playing sports or football and the ankle injury? So in this instance, their argument is that the patient's purpose of obtaining the letter to avoid eviction was not healthcare related. In this sense, it was related because the doctor was promoting the safety and welfare of his patient with regards to eviction as it relates to the fear of her anxiety.
If the letters had just said, Kingston is a trained service animal and nothing else, would your argument be the same?
Yes.
Why is
Kingston
that?
is a service animal. Because, first of all, under the ADA.gov, which is referenced in the record, a service animal is defined as one who performs a task. So Kingston is trained as a service animal. The question then becomes, what is the physician's obligation under that circumstance? So again, it's raising the issue in the context of what is the accepted standard of care for a physician under that circumstance making a determination, which, as the ADA.gov says, must be related in order to state that they are a service
But again, in
dog.
my hypothetical, it's not saying anything about her, it's just about Kingston.
But the service animal, as defined in the ADA.gov, must be connected to a disability. So there is a conclusion in
So a service animal, and just tell me, I might not know enough about this, but if Kingston is indeed a trained service dog, which seems doubtful given what he did, but if that's the case, does his status as a service dog transfer to someone else, or is it like he's a service dog, he's been trained, or is it connected only to the particular person with a particular disability? And he's treated as a regular old dog if somebody else.
With respect to our letter, it is
Well, I'm
only.
not, but again, my hypothetical is not your letter. My hypothetical is he just writes a letter about Kingston. It doesn't say anything about
About a
Romano, about the patient, about her disability. Just Kingston is a service animal.
Well, I think that I would ask about the context. If he's just writing a letter about Kingston as a service animal, and he doesn't have a patient-physician relationship like we have here,
Yeah, that's what I'm suggesting.
then there would be a different scenario where it's completely outside of the context.
And so the question, and I understood this from your briefing, was whether or not that statement was separable or inseparable. And is that the thrust of your argument, that they're inseparable? So if it were just the statement, if it were separable,
Right.
and if this court were to say, we think that they're separable, do you then say, all right, fine, we have to move on, or do you have any other arguments?
If we didn't have if we had a dispute about whether this was in the context of a patient-physician relationship, then we would be we would have an issue as to that first basic element. The court has addressed those types of cases when it does look at a different set of facts or as to non-healthcare providers. And so when we looked at, for example, in the cases like with regards to the security guard or a malicious prosecution matter that is separable from the actual incident involving the patient assault. In that case, the police officers and the security guards were non-healthcare providers, and in that circumstance, we could split that.
There's nothing that could be in this letter, nothing that he could write in the letter, because it's a letter about a patient. Just anything he would put in there at all is inherently inseparable because he's a healthcare provider?
I do think that our statute is very, very broad, and it does provide a rebuttable presumption under Loisica that says that when you complain of a physician for any act that the physician provides within their license.
But I guess the question is whether or not, when you say it's a rebuttable presumption, it sounds close to being an irrebuttable one under your theory. But let me ask you, let me just shift for a second, because you haven't really made this argument, and I have some of the concerns about the one that you have made that have been shared. But I'm curious as to whether or not, regardless of what Dr. Leibman did, what these letters said, what in the allegations causally links that to the injury that was actually visited upon this poor little girl.
I agree. There is.
So if that's true, that's a standing issue, isn't it? It's not just a merits question of causation. It's a question of whether or not there has been sufficient pleading, and we've gone through discovery that shows traceability. And so if this dog could have gone into this restaurant, whether or not he was certified by Dr. Leibman, which I understand from what I've looked at in the federal regulations, I mean, the restaurant is limited in what it can do when somebody comes in and says, doesn't even have to have a service dog thing on
Correct.
it. They're allowed to ask questions. Is this for a disability? What is it that he's been trained to do? But my understanding is the restaurant didn't ask any questions at all, just in he came. So what I'm wondering is there standing to bring this claim? And if not, that's a jurisdictional issue, isn't it?
I would agree, Your Honor, but I would say first, the dog was never represented as certified by Dr. Leibman.
Okay, but even so, I mean, the point is, even if he were, if that had nothing to do with tracing the alleged conduct, I mean, and surely for standing purposes, the allegations about what Dr. Leibman said, we're going to take that at this stage.
Right.
But even accepting all of the things that are alleged, if there's nothing that traces this vicious attack on a small innocent child by a so-called service dog on what Dr. Leibman did, how is it that your client is someone that can properly be brought into court at all?
Well, I mean,
I guess I want to know, are you conceding this? I mean, it's not something you can concede, we have to decide our own jurisdiction. But are you saying that you think that they've alleged sufficient traceability for standing? Or are you telling us, or are you otherwise saying, well, it's true, you haven't invoked it, but we really ought to think hard about standing?
I do think that we should think hard about that because there isn't actually, and we believe that to also be a merits issue with regards to, there is nothing in this record that shows how or when Romano obtained any kind of information regarding the service vest or the service card in the evidence to bring the dog to the restaurant. And so there isn't actually any evidence before the court with respect to that record. And I do think that you raise a very, very important point, which the court may independently consider regarding standing as to whether or not that the conduct of Dr. Leibman was caused Romano to bring the dog into the restaurant. But from that standpoint of, the only point I make with regards to certification is that was something that the Court of Appeals accepted from the argument, and the evidence before the court doesn't actually show that there was any certification or a representation regarding this dog on the certification. And I think that with regards to your point, the only letter that is written that refers to this dog is the December 2019 letter, which in the context talks about this patient, which is undisputed that there was a relationship, and her medical condition.
Well, if we have to get to the merits, I'm troubled by the idea that these are inseparable. but I'm not sure we have to get to the merits, and I guess I'll ask your friend on the other side that question as well.
Any
So-
other questions? Thank you, Ms. Chang.
Thank you.
We'll hear from the respondent.
May it please the court, Ms. Farrell and Mr. Herbert will present argument for the respondents. Ms. Farrell will open with the first 15 minutes.
Good morning. May it please the court. The gravamen of the Waldroup's claims is the statement that Dr. Leibman made about that dog, about Kingston, a vicious dog with a prior bite history that mauled our 3-year-old client. In another dog case, the Village Green Alzheimer's case, the first Court of Appeal said not every action a healthcare provider takes on his premises can be shoved under medical care.
Can I ask you, can you comment on Justice Young's questions that have to do with the sufficiency of the traceability for standing?
The causation question.
Standing question.
So in order for the Dr. Leibman to articulate that this was an HCLC, that the injuries were proximately caused by the actions of the healthcare provider is an element of that. The Court of Appeal acknowledged that when they said the causation for the purposes of determining whether it's a healthcare liability claim is not in dispute. And so in order for us to be standing here today, Dr. Leibman would first have to have acknowledged when he says this is a healthcare liability claim that his actions were the proximate cause of our client's injuries. That's presumed in bringing up the presumption that it's a healthcare liability claim.
Well, he cannot concede, and it's a pretty tough situation for someone to be in, to say, well, in order for me to be able to benefit from this important statutory procedural protection for doctors, I now have to concede something that is jurisdictional. And if you do, then that's gone. Perhaps luckily for him, jurisdiction is not something that is waivable. Whether he concedes it or not, we have to be able to independently assess whether or not the allegations, and I guess at this stage, given the discovery has happened, whether or not there's something in this record that shows a plausible basis for thinking that this attack on this innocent little girl, and I'm not in any way suggesting that what he did was good or that this service dog is a great dog, anything. I'm simply asking whether or not there's anything that's alleged that says that this attack would not have happened if Dr. Leibman had done something different.
The letter that Dr. Leibman wrote about this particular dog, the one that you might have seen in the record, Kingston goes between the doors, Molly licks her face, that letter is the most recent letter. It's the most proximate letter to the injuries. There has been no discovery on the case at all, because first we have to deal with the healthcare liability claims.
What have you alleged even that says that if he had not written this letter, or if he had been truthful and not made assertions that are beyond his capacity? And I take your point. If this is something that gets to the merits, I'm not fighting you at this point. I'm simply asking, whatever it is that happened in this case, what have you alleged that says that she couldn't have gone into this restaurant with Kingston if he hadn't written this letter?
Or that she wouldn't have.
Or that she wouldn't have.
Right, so that's the allegation.
Not completely speculative. That's what we need for standing, right? And the letter seems to say this is what Kingston does. It sort of describes Kingston as already certified. Even the stuff about the eviction, which I'm not sure if that's still really part of the case or not, but it was trying not to save her from losing her dog. It was trying to save her from losing her apartment, which is to say she's keeping this dog, and she'd like to stay in the same apartment. So she's got the dog. The dog is already described in the letters as certified. It's, probably a lie. I'm not, I'm willing to stipulate that at this stage at least. But I don't see a world in the allegations even, much less in anything in the evidence, in which whatever Dr. Leibman says, we don't still wind up on this terrible morning and this dog still doing the terrible thing that happened, which makes me wonder, I'm not challenging standing as to other defendants. I'm challenging it, I'm questioning it as to standing to sue Dr. Leibman.
But for Dr. Leibman's letters, the Jennifer Romano would not have continued to pass this particular dog off as a service animal.
Well, and that she would not have had this dog specifically at this restaurant at this time, but
I
there's
mean-
some way to say that this accident would not have happened but for, and beyond but for, under legal causation.
And that Dr. Leibman, I mean, we don't have an aiding and abetting tort in Texas, but that he conspired or participated with Jennifer Romano and her fraud on.
But whether he had done that or not, how did that make this accident something, this terrible event, something that wouldn't have occurred otherwise?
I think that is a good causation issue, but I do not think that it rises to a level that it would deny it standing to even be
So
here.
it's the issue of standing I'm talking about, just to be very clear, and I don't want to eat up all of your time, and I know this is not what you planned to talk about today, but it's traceability, right? Tracing the complained of conduct to the injury that you're seeking to redress by damages. And so again, I won't ask, this is my last question to you on it. You might want to consider whether you want to send us something that describes this in greater detail when you have a chance to think about it more. But what traces the specific conduct that you're complaining about to the injury?
I will take that on board, and part of it is that's a fresh issue, which is fine, but it has to be conceded for the purposes of the conversation we're having about healthcare liability claims.
Assume that I reject that.
Okay.
And I think that we have an independent jurisdictional obligation to establish it, not in the formal merit sense, but in the traceability sense, which is closely related to it, but is not exactly the same. Maybe you wanted to send a letter in a couple of days instead of spend more time here about it, because I know you feel ambushed. It's not your fault, but I think it's important, and I'd hope maybe that we would have given more thought to it. But if you would give a little more thought to it and send a letter in, that would be very helpful to me.
I will,
All
certainly.
right, now please,
Thank
without
you.
me derailing you on what you wanted to talk about, please.
No, that's fine.
Could you talk about whether the case would be any different, your position would be any different about whether this is a healthcare liability claim if instead of sort of mentioning Kingston, the doctor's letter recommended a standing desk and said, you know, I trust this particular brand. And then the standing desk ended up really hurting some people, you know, after it was installed.
So that was a great analogy. So if he said that the patient has problems with her back, healthcare. Patient could benefit from a standing desk, healthcare. I've inspected this particular standing desk, Acme standing desk, and it's safe, it has these features, and I recommend it, right? I give my imprimatur on this standing desk. That's not healthcare. And that's the severability part of it, is that in this particular case, and it's on these facts, the statements about Kingston the dog are severable from what is the healthcare.
I mean, that seems then, under your theory, that it's not healthcare to recommend a particular brand of statin,
A particular brand of?
of a drug.
Oh, right. So that is healthcare because that.
Why? How's that different?
Because that is something where there is an accepted medical standard of care, where when the doctors are trained to opine on that, they're trained to give prescription advice. So if you apply the St. Luke's factors about safety standards, that is directly related to healthcare.
What about a standing desk, as was asked earlier?
So-
My diagnosis is the patient has a bad back and requires a standing desk, and I find that the Acme desk is the one that's probably best suited for her and will serve the purpose. And it turns out the Acme desk has a product defect and it collapses. Is that healthcare? If the allegation is that you negligently, not that you negligently recommended that she needed a standing desk, but that you negligently recommended the Acme desk.
This particular desk. I think that is a much closer case because it falls within physical therapy or occupational therapy, which would have some applicable safety standards for which you would have medical expertise would be required. So if you were to push me, I'd say if it was a standing desk as part of occupational therapy, I think I would say that I agree that that might be healthcare, because I know that the expert I need is one who's an occupational healthcare expert, right? Here, who's my expert? Somebody mentioned it. It's an animal behaviorist or a veterinarian. Those are the experts because there is no applicable standard of medical care applicable to this dog.
So is it different than the standing desk because it's a third party that's harmed rather than the patient, or because the feature of the desk, say, I recommend this for back problems, and what happens is the desk falls over and hurts somebody who comes into your office, and that's not the thing that the doctor was examining the desk for to say whether it was good for the purpose of treating the patient. That seems a little more like this case. So how would we analyze that differently if the doctor examines the desk and says the patient needs this for their back problems, and it's safe and effective for that purpose, and then the desk falls over and injures somebody who comes into their office?
So I don't think that we escape it being potentially a healthcare liability claim because we're a third party. There's lots of case law in that, the prescription medicine case, which I really think is the applicable sort of analogy to the standing desk. So that's Buchanan, I think O'Donnell, where the doctor writes prescriptions for painkillers, and a third party is injured because the patient was abusing those painkillers. It's a précis of the fact. This court said it doesn't matter that it's a third party. It doesn't matter that that medication was not being used as directed. It's still a healthcare liability claim because the applicable standard of care is a medical one. Whether or not the doctor wrote those prescriptions negligently or not, that's something that only a medical expert could opine on. Here, which was, I think, to your question, there is no applicable standard of medical care that answers the question for us about whether Dr. Leibman was competent to say anything about Kingston the dog.
Why isn't this a letter like this an administrative service related to healthcare?
So because it doesn't directly relate to healthcare. So again, if the letter said, Ms. Chang pointed out that there were a number of letters, right? A letter that says Ms. Romano has generalized anxiety disorder and could benefit from the use of the service animal, that is an administrative service. And in fact, that would have sufficed under the Fair Housing Act and the HUD circular to fulfill the requirement of the do you have a disability? Doctor's job is done then. So those letters would have been an administrative part directly related to healthcare, where he's off-piste in talking about what Kingston can do. That's not directly related.
Couldn't you get an expert to say that's beyond the scope of what a doctor ought to be recommending, and you should have stayed silent on which dog or the dog's suitability?
The medical expert, that's not typically what the expert would be opining on. It's whether there was a breach. What's the applicable standard? And I don't think the applicable standard typically is this the sort of letter that should be written, but rather is the content of the letter negligent or not? Was the doctor negligent in giving in the content of the letter?
Yeah. I mean, these are all sort of close questions, and we're stuck
Sure.
with this statute, and this gets debated all the time. And so I wonder whether in a case like this, when it's your position that it's not a healthcare liability claim, and
Correct.
that's a defensible position, I think her position is also defensible. When you know that her position might be defensible and some judges might agree with it, why not try and get an expert report in case she ends up succeeding on the point that it's an HCLC, and then because if you don't, then if she succeeds on that point, your case is dismissed. If you get an expert report, then we're sort of in a different world where even if she wins, you might be able to amend it, and you and your client are much better off if you protect yourself. Why doesn't that happen in these cases?
So that actually speaks to the independent ground for affirmation that we brought up with respect to that Dr. Leibman, nobody suggested that this was a healthcare liability claim until a motion for dismissal was filed.
You're suing a doctor for a letter he wrote for a patient about that has to do with her psychiatric problems. I mean, it's foreseeable that somebody might argue this is a healthcare liability claim, and that if you haven't got your expert report in line, that you're going to have problems, and the remedy is so nuclear, right? The dismissal of the claim. That it seems to me, I'm surprised in these cases why people have not have sort of gone out on that limb, and just gone without an expert report, knowing that someone might argue that you should have had one, and then your case is dismissed.
We would not have known what expert to instruct on this point, a medical expert, to instruct because of the gravamen of the claim was the statements about the dog. and we did not allege so in almost all of the cases where this court has rejected due process challenges to the dismissal, to the draconian dismissal, in all of those cases, everybody knew that the doctor was claiming it was an HCLC. It was explicit. So here, where it was neither alleged, nor did Dr. Leibman suggest that he thought it was an HCLC, the plaintiff wouldn't have known what expert to instruct, because a medical expert would have been, we think, inappropriate to instruct a medical expert to opine on whether or not Leibman was competent or breached a medical standard of care about the positions of the dog. And so, I mean, that's why. We wouldn't have known what expert to instruct.
Let me ask you about your...
Just to finish it, but if you do file something, or submit something as an expert report, even if you don't know exactly what they're going to argue it should be in it, then you get to amend it later, right? And we're not stuck with the draconian remedy, as you say, of dismissal.
You know, the statute foresees the possibility of getting a preliminary ruling on whether or not it's an HCLC. So that would also be a way to fulfill the purpose of the statute, to decrease litigation, to speed it up, and to reduce costs. But that requires there to be some cooperation in asserting an HCLC, that it is an HCLC in the first place. And so the burden of proof is on the doctor to show that it's an HCLC. And I take your practical point, but by the same token, hiring and paying for the wrong expert, or an expert whose opinion is not actually relevant, is a very high burden on the plaintiff, when actually it's the burden on the doctor to show that it is a healthcare liability claim.
Any other questions? Thank you, Ms. Farrell.
Thank you so much.
Mr. Herbert, we'll hear from you.
Good morning. You guys are already fairly deep into this argument, so if you have questions, fire away. I thought I would give just a brief overview and take a step back and look at the kind of broad picture of this case.
But before you do that, your colleague brought up the independent ground of the waiver argument, and I wanted to ask you about that, because the statute says the failure to provide the authorization along with the notice of health care claim shall abate all further proceedings against the physician or health care provider receiving the notice until 60 days following the receipt of the required authorization. So there doesn't seem to be a dispute that there was no authorization provided, probably because y'all didn't think you needed to provide one, because
Correct.
It wasn't a healthcare liability claim. So was the effect of that statute to abate all further proceedings, and then as a result, the deadline for you to file an expert report never ran? If an expert report is even required, because there seems to be a split in the Court of Appeals on this, and so I'm curious about your view. What happened when that was not provided? Assuming that we agree with the other side, just for purposes of this argument, that this is a healthcare liability claim, it seems like there's an abatement in place.
I apologize. That is an area of this case that my very competent co-counsel handled completely, and I'm happy to turn over the podium to her and let her answer that question. Okay. Big picture, Dr. Leibman could have fulfilled all of his duties to his patient by simply stating she had a generalized anxiety disorder. He did not need to make a statement about this particular dog and its particular qualities. I think the court has pointed that out.
Was he negligent in doing so?
As to the second part of saying Kingston is a certified service animal?
Yes.
Yes.
That's the allegation.
Yes.
Because that was unnecessary in the
And false.
context of in the context of providing a letter to his patient about her disorder.
Absolutely, correct. He could have fulfilled the standard of care, which is to examine the patient, make a diagnosis, and provide the letter. He didn't need
Why
to.
is it going beyond the scope of what he ought to be opining on and talking about as a doctor? Just a medical negligence claim, just the same way as if you do a surgery that you shouldn't be doing because you're not qualified to do it. Or...
Excellent question. I think what the courts delineate here is in the cases where you've got a situation like a bad script, right? That's closely analogous. The point there is when you write a prescription, there is a medical standard that doctors are trained on when they examine human beings, right? Make an appropriate diagnosis, prescribe the correct medicine, warn your client of what that medicine will do to them, and then monitor the success or whatever happens with the medication. There is no such standard in the context of a service animal. Doctors are not trained on it. Veterinarians might be, other folks are. But he could have fulfilled his duty to his patient by simply not talking about this particular dog has particular qualities that he did not in fact know about.
But isn't that precisely what you're just articulating the standard that the expert report ought to detail, which is that you're breaching a duty by going on to make recommendations about which you're not trained. I mean, that is a medical standard. Why isn't that a medical standard of care?
Because
to not talk about stuff you shouldn't talk about.
Well, when you retain an expert in a case like this, you have to ask them, what did the doctor do wrong? And in this case, it's just not something that a doctor's supposed to do. It's just so far, it's just beyond what he's trained to handle. So I don't know that an expert, should every lawsuit in which a doctor or a hospital is a defendant, should plaintiffs be required to submit a report that says hospitals and doctors can't certify that trucks should be on a road because they are in good working condition, right? Doctors can opine that you don't have epilepsy anymore, so now you can get your driver's license. You're not obese anymore, and so now you're not hypertensive anymore. So now you can operate a truck under the federal standards. Doctors do that all the time. But they don't opine, this is the vehicle that you need and I've inspected it and it has special qualities that are good. That's a step too far. There's no substantive nexus between saying this is a certified service dog, which was false, and rendering the care to his patient that was necessary, which was simply saying she needs a service animal. Full stop. And so I understand there are similar issues. This is a bit of a strange case. But the point simply is doctors examine humans, not dogs. Doctors examine humans, not trucks. Doctors examine humans, not necessarily standing desks. And when a doctor says, I certified this thing, this dog, that's beyond the scope of what doctors contemplate as part of their training and their licensure.
Any other questions? Thank you, Mr. Herbert.
Thank you all.
Ms. Chang, you have 5 minutes.
So let me ask you about the independent ground. Is because of the operation of the statute that I just mentioned, was the deadline to file the expert report abated?
No.
Why not?
Because we deal with that all the time with regards to notice of claim and authorizations, and those are things that the defendant is entitled to abate the case in order to obtain the relevant information and then proceed.
Well, it doesn't say that the defendant may seek an abatement. It says failure to provide the authorization shall abate all further proceedings. That doesn't seem optional.
Well, with regards to the authorization, if the authorization is not provided, then in the context of the trial courts, that case proceeds if the case is then filed.
Okay, and it can proceed, but what I'm asking is once people say, oh, well, maybe this is a healthcare liability claim, then aren't the deadlines related to that abated by the force of this statute?
And I would not agree.
Okay, well, the courts of appeals seem to be split on that, and people haven't really addressed that, and it seems like that's a threshold question before we even get to whether, I mean, you've addressed it a little bit in the context of this, whether there was waiver or not.
Right.
But it seems like we need to decide that before we ever get to the issue of did they fail to file an expert report if their deadline to do so has not even run yet.
Well, and I believe in the context of whether there's an abatement, the court addressed in Lidgy whether or not the tolling of the statute of limitations in that similar context with regards to the Chapter 74 authorization. And in that context, there was a tolling of the statute of limitations. But in this context, with regards to the expert report, there really isn't any exception within that 120 days, other than the ability to
case
cure.
from Dallas disagrees with you about that.
Right, and as the court has mentioned, that there is a dispute within the Court of Appeals. I did want to address Justice Young's tracing issue, and I would ask that we be allowed to brief that issue because, as you mentioned, there is no allegation that, apart from a purpose of eviction, that but for Dr. Leibman's letter regarding this animal, Romano would not have gone to that restaurant and been able to bring her dog into that restaurant or represented the dog as having any service.
Yeah, I'd appreciate a letter that would address that in the constitution of our standing jurisprudence and the traceability of whatever the allegations are that he did, not necessarily what the purpose was, but what did he do and how did that, and if you think that our cases would suggest that the traceability is defeated, explain why that's the case.
Right.
And I'm sure your friend on the other side will do the same.
And the point being that in the allegations currently, in the live pleadings, there is nothing that makes that connection. And with regards to Justice Huddle's question regarding the standing desk, that would be a healthcare liability claim with regards to the Acme desk. If the physician wrote that this patient's particular back injury, perhaps it's an L3 or maybe it's cervical, is benefited by this particular desk.
But
And
what if what the desk did was not injure the patient, but it fell over and hurt somebody who walked into the office?
And the Chapter 74, the Act covers under the broad definition of claimant, non-physicians.
But the advice, but the problem with the desk was not anything that the physician opined on.
But the allegation against the physician for stating that particular desk was for this patient, if the allegation, as in this case, is this particular dog was provided a service to the patient, then in that circumstance, it's a healthcare liability claim against the physician.
If a doctor recommends a particular modification to a vehicle for somebody to use in order to be able to operate it with a disability, and for an unrelated reason, there's a problem with the engine, and there's unintended acceleration, and it runs somebody over, that's a healthcare liability claim because the doctor recommended that car with that modification?
I think that goes back to whether it's in the scope of that doctor's practice with regards to that particular modification and what are the questions you ask about that modification. So that's really going back to what a physician in Dr. Leibman's circumstances would ask, what steps would he take?
Well, what is a physician going to say about the unintended acceleration of the car?
If it's unintended, I think we get back to a question of jurisdiction and standing. So if there's nothing that Dr. Leibman could say or would have said or would have changed the outcome with regards to that, then we don't have the causal connection. And again, whether or not it directly relates to healthcare has been addressed by this court in the context of safety standards. On the issue of affirmatively stating whether or not that was raised on the waiver issue, that has been addressed by the court with regards to Walker versus Gutierrez in terms of there's no obligation to provide notice of noncompliance or notice of the law. And that was addressed by this court. In conclusion, we just ask that the Court of Appeals decision be reversed and that the case be remanded for dismissal pursuant to the Medical Liability Act. Thank you.
Any other questions? Thank you, Ms. Chang. The case is submitted and the court will take a brief recess.
Ayes. Hey, how's it going? Thank you. It's my coworker.